wasn't served until 1999, which would be beyond the 120 days for service of process. The law demanded, and I'll go to Gaines versus Placilla, and we can go to 634 SO2D 711, 0, where it says that an action be dismissed without prejudice where service is not made upon a defendant within 120 days after the initial pleading where there is no showing of good cause for the delay. And as we look at the clerk's record, we see that that did not happen. So I'll just say that the court erred in not dismissing the case at that point. We go further. Because it doesn't show that there was a good cause for failure to serve the defendant within 120 days, Rule 1.070, which mirrors 12.070, states that the trial court should have dismissed the case. And we go to that Patterson versus Lowenstein, you have that as well. And I think that most of these are pretty clear. And back to the issue of res judicata, I want to cite the Florida Department of Transportation versus Giuliano, and that's 801 SO2D 101/105, that the issue had to be litigated and determined. And to date, there's been no definitive ruling as to whether or not the court's position is that it had subject matter jurisdiction and definitely didn't have personal jurisdiction for the case. So again, I'm challenging jurisdiction. I don't know if you have the capacity to even rule on this matter, but let's continue to move forward. It's well settled that a trial court may not exercise its discretion to refuse to dismiss a case under Rule 1.070I unless there is record evidence of efforts made at service during the 120-day service period, which would support a finding of good cause under the rule. And even if you may have made an attempt, you had the duty as attorneys to ask the court for an extension of time to serve their initial complaint and process. That, of course, in the record is not evident. Moreover, when this action began in 1998, the Hodges versus Knoll holding would have been the binding case law, and you can go to 675 SO2D 248, 249, that's 1996. Now, as to the language for the time limit for service of process is pretty unambiguous, and because it requires that an action shall be dismissed without prejudice, absent a showing of good cause why service was not made within 120 days, the discretion afforded the trial court is limited to those cases in which a reasonable cause for failure to effect timely service is documented. I tell you again to take mandatory judicial notice, of the clerk's docket for case 1995 DR 6110 that's filed within the Hillsborough County court. There's no evidence showing of good cause, and there definitely was no extension of time to serve process. That final judgment does not have a child support guideline worksheet attached. And it is error for the trial court to decide the issue of child support without the benefit of a child support guidelines worksheet. And that's actually Florida Family Law Rules of Procedure 12.285, and that was J. And I subsequently tested Durham versus DOR, which you can cite it at 850 SO2D 653, and that actually came out of the second DCA back in 2003.
Did you actually complain about that in your motion, the emergency motion?
I don't think I have to, but you're aware of it now. Whether it's just a simple issue of a 1983 issue, or if it's an abusive process, nevertheless, the rule is clear, and I'm pretty sure that Ms. McCarthy is aware as well.
When did that rule go into effect?
Doesn't matter when it went into effect. It was in effect in 2003.
Okay.
And unless you have some rule that would supersede what would have happened, but necessarily in 2003, then we're still where we are. And it still doesn't undo the fact that after the 120 days you didn't serve process. And that's been in effect since that's one of the bedrocks of American jurisprudence and jurisdiction.
Okay.
And in looking at the record, by the way, The case came out of North Carolina. Ms. McCarthy made a comment that Florida court had always had jurisdiction, and that's inside the transcript. Now, what I want Ms. McCarthy, because she made herself a witness, she testified to that when she said it. When did Monica Smallwood file a application for services in the state of Florida? Because I haven't been able to find that, and my request for production hasn't seemed to have produced that.
Are you calling the attorney as a witness?
The attorney made the statement. I just need anybody. Ms. Britt can do it. She's the representative for the Department of Revenue.
I don't think that's something to be testified to. It's in the court record.
Can you please provide it? Since you said it's in the court records, I appreciate that. Can you
Read the
please?
petition. It's under the U.S. Florida Statute 88. That's how jurisdiction is obtained. We went over this the last time.
No, we did not go over that. Is it your position that Ms. Smallwood filed that complaint in Florida?
It's,
Okay, so
it was filed through the child support agency, sir. Once again, Florida Statutes 88.
I need the evidence of that petition, because what I do see inside the record is a summons, and what's not attached to that summons is a petition, not the original summons. I find that to be pretty interesting, and I'm aware that Minish and McIntosh was notorious for some unethical behavior, but I'm demanding, not even asking, I'm demanding, because you made the statement now on the record, to show me the original petition filed in the state of Florida on behalf of Ms. Smallwood, because I'm familiar with Rule 12.040 C2, where the representative for the department only represents the department and not the recipient of the services. So I need to see, because she's now made it, and I can give you time if you want to continue this, for Ms. McCarthy to produce that petition, the original complaint and petition that was filed back in 1995, because it's not in the record. And I know Ms. McCarthy would not do anything that would violate the rules of professional conduct.
What do you want from me, sir?